File item 73, AB 1850. Clerk will read.
Assembly Bill 1850 by Assemblymember Gonzalez, an act relating to employment.
Ms. Gonzalez, you may open.
Thank you, Mr. Speaker. Last year, we passed AB 5, and I acknowledge that our work addressing misclassification that has gone unchecked for decades was not finished. I made it clear that an undertaking of this magnitude would be a multi-year effort to get it right, and that's what 1850 seeks to start to do. I want to thank my colleagues who continue to approach me to work collaboratively through these complex issues. In AB 1850, I've made clarifications that provide greater certainty for musicians, writers, and certified translators, photographers, multimedia professionals, professionals providing risk management and appraisal services, expert judges, specialized artists who teach, and others under the law. The process of crafting reasonable clarifications for each industry has been consistently informed by the principles found in the Dynamex case itself. As I continue to work with and implement feedback from workers and businesses, I intend to address the following things in the Senate. Issues specifically raised by interpreters who work through referral agencies, broadening the definition of a referral agency to make clear when someone is and is not an employer in that situation. Amendments proposed by photographers who do not want intellectual property rights laid out in their contracts. Performing artists who present their original work, and further address any outstanding issues that will help promote compliance by hiring businesses. I respectfully ask for an aye vote so we can continue to grapple with this complex issue.
Thank you, Ms. Gonzalez. Mr. Kiley, you are recognized in the rear of the chamber.
I have a question for the author.
Without objection.
When this bill was in committee, you said, quote, "They were right, I was wrong." You were talking about writers, but you could just as well have been talking about the 20 or so other professions that this bill frees from the clutches of AB 5 to varying degrees. Now, I commend the admission of responsibility, and I mean that sincerely. But it isn't just that you were wrong. It's that you legislated that mistake. You gave it the force of law.
Stage point of order, Mr. Calderon.
He said he had a question. He needs to ask his question.
Point of order is well taken. Mr. Kiley, please frame your question so the Assemblywoman may address it.
That's what I'm doing. You gave it the force of law before making sure that you were right. And the result was incalculable hardship and heartbreak for many, many people in our state. So just looking at the people that are affected, that are in the professions affected by this bill, we've seen businesses shuttered, we've seen lives upended, we've seen careers ruined. So my question, Assemblywoman, is this. If by your own admission you were wrong about so many professions at such a high human cost last year, why should we be confident today that you're right about the hundreds of professions that remain subject to AB 5?
I'm going to answer that question despite the fact that I don't think you understand what you're asking. The reason I said that, it had to do specifically with how we dealt with freelance writers. During the process of AB 5, I met with organizations that represented freelance writers and photographers. We went down a path on submissions. A lot of you have heard about this, the 36 submissions. And our negotiations centered around the number of submissions. That was with the organizations themselves who represented freelance writers and photographers. After it was signed and people realized this came in, a different group of writers who wrote in a different fashion came to see me. And they said the submission issue won't work for us. I had never heard from them through the process. And they said that just won't work because a blog item might be one submission rather than you're thinking of a story. And I took countless meetings with them to better understand. The indication that you were right and I was wrong had to do with the fact that it can't work for them. And so we have adjusted it as we continue to do, as we hear from individuals who have issues. The fact is, our labor code wasn't written in one day. We have hundreds of examples in SDI and UI where there are exemptions, and those exemptions and clarifications have been done over years in our code. The Supreme Court gave us a blunt object, an ABC test that applied to everybody. And the countless hours that I've actually spent not online tweeting my dissatisfaction, but actually spent with individual workers and businesses and industries and attorneys is to get it right. And when we don't get it perfectly right, to adjust it. Because after 40 years of massive misclassification and a Supreme Court decision that provided a lot of guidance, but really no specific path, this is important work to do. So I'm going to continue to do it despite this complete inability, despite my offers to sit down with any member of this legislature who wants to come talk to me about this. And I will continue to take your criticism and your questions, but it would be great if you actually sought to fix this, to fix what Dynamex gave us, to continue to work on this issue and make sure that workers are protected, because during this pandemic, we have learned more than ever why it's important that workers have unemployment insurance. We have learned why it's important that workers have paid sick days, why they have family leave, why they have health care. And rather than just trying to blow it up and suggest that somehow the bartender at a catering business should be an independent contractor when they were never independent contractors under Borello. That's just flamboyant political talk and not seeking solutions. I'm going to continue to seek solutions, and I'm going to continue to work with people who want to work through this.
Mr. Kiley, you may conclude your remarks.
To be clear, I did attempt to fix it with a bill. My colleague from Big Bear attempted to fix it with a bill of his own. Neither received a hearing. But this has been the standard response we've gotten to all of the heartbreaking stories. We knew it wasn't perfect. We're working on it. We're cleaning it up. We're meeting with people. That's what you do before you pass the bill, not after. Especially a bill like this, which turns upside down the relationship between citizens and government.
30 seconds.
No, her time does not count towards my speech. It used to be—
Mr. Kiley, you have 30 seconds remaining.
I do not have 30 seconds remaining because you're counting her time. Is that point of order?
Mr. Kiley, when you ask a question and it is addressed by the Assembly member, the clock is running. It was a long question, a considerable answer. You may conclude your points. We have additional debate on the floor.
That has never been the way that rule has been enforced in this chamber. The expression is on my own time because you're not counting the response. But I will conclude my remarks, and I know there's another bill on this topic, so I will use that opportunity to address them.
Thank you, Mr. Kiley. Mr. Obernolte, you're recognized.
Thank you, Mr. Speaker. This bill makes some modest improvements to the framework of AB 5 last year. In the spirit of trying to be helpful, I'd like to suggest some ways that it could be further improved. Unfortunately, the coronavirus situation and the shortened legislative calendar curtailed our ability to have that debate this year, but make no mistake, it is a debate that needs to be had. So this bill adds a couple more professions to the list of industries that are either exempt or are governed by the old Borello test. Unfortunately, it also illustrates one of the big problems with AB 5, which is that AB 5 says, here are the new rules for worker classification in California, but then spends pages and pages and pages of state code talking about exemptions for this industry, exemptions for that industry. This bill, we're adding exemptions for musicians, we're adding exemptions for youth sports coaches, we're adding exemptions for insurance agents. But let me suggest that the way that the bill should work and the way that state code should work is that we define a framework that works for everybody. And so I have a couple of suggestions in that line. I think that we should expand the professions exemption under AB 5 to cover all of the professions in the Business and Professions Code. Those are professions that already have code sections dedicated to them. We can legislate tweaks to the rules for those industries under the BNP code. I don't think that we need to go industry by industry in the framework of AB 5. I also think what's badly needed is an exemption for highly skilled workers. That is something we wouldn't be reinventing the wheel on. It's already defined in state code and the wage code. Those are workers that have the power to negotiate with their employers, and I think that an exemption for them would really help to clarify this issue. I also want to talk about the need to add some specificity to AB 5. One of the big problems with AB 5 is it says that if your worker is performing work that's in the usual course of a business for a company, that company cannot classify them as a contractor. But we never define what usual course of business means. And unfortunately, that lack of specificity just throws it open to the courts, the interpretation of that code section. And frankly, that is the problem that led to the original Borrello decision and the Dynamex decision, is this legislature's failure to define in state code exactly what we mean. Colleagues, we should not be abdicating our responsibility for writing law to the courts. We need to fix that problem. And then lastly, let me say that we badly need to create a small business exemption in AB 5. You know that 30 years ago I started a company out of my college dorm room. I can tell you with 100% certainty I would not have been able to do that if AB 5 had been the law of the land. Colleagues, it is just too hard to start a business simultaneously with trying to hire employees and comply with the complex framework and regulations that that entails. So I fear that AB 5 and the framework that accompanies it is really going to have a detrimental impact on entrepreneurialism in California. And unfortunately, the companies that are created here and the jobs that would have been created here will still be created, but they'll be created in other states, and the prosperity that comes with them will be there too. So unfortunately, I had a bill on that this year. It was not heard. I would want to urge this legislature in the months to come to take a serious look at this framework and to fix some of these systemic problems. Nonetheless, the bill before us certainly makes some improvements to the framework, however modest, and I would urge an aye vote.
Thank you, Mr. Obernolte. Mr. Kalra, you are recognized.
Thank you, Mr. Speaker. And I appreciate the comments from our colleague in recognizing that this bill does make improvements. And the reality is Dynamex was a landmark case that then threw upon us as a legislature to try not just to interpret what the court said, which was very clearly that misclassification has been a major issue for many decades, but then to give us the opportunity to try our best to manage the interpretation of that case in how it's actually defined and executed ultimately by the state, by the administration. And I just want to, I felt the need to at least respond to the rage of our colleague from Roseville that a bill wasn't heard. In my committee, just like many others, the bill load that was heard was probably 30 to 40% of those that were introduced. We did have a lot of bills that were introduced related to Dynamex and related to AB 5, both Republican and Democrat. Bipartisan bills that were put forward. The far majority of those that introduced bills never actually spoke to me about the bills they introduced. We did have bipartisan, both but Republican and Democrat bill ideas that were brought to me that were actually incorporated subsequently.
Mr. Calderon, stage point of order.
I just want to remind members that we're here talking about AB 1850. The subject matter with which you speak has to be on that bill, directly with the subject matter that is in that bill, not on anything else. So I just want members to please stay on point with the subject matter that is actually in this bill that we are debating right now.
That point of order is well taken, Mr. Calderon. Mr. Kalra, please confine your comments to what is germane to the bill in front of the body.
Thank you, and that was my next point, is that those ideas have been incorporated into this legislation because those authors actually reached out to the Labor Committee. They actually reached out to the author. Our colleague from Roseville never once called me, talked to me, texted me, passed him in the hall one time about this bill that he's now outraged didn't get a hearing. And so the Twitter rage may be real, but the rage that is being expressed here does not represent how bills get passed in this body or should get passed in this body. It's no wonder he doesn't have too many to his name. It's because you actually have to talk to your colleagues, you actually have to work with your colleagues in order to try to find common ground. And that's something that Assemblmember Gonzalez has done. Even when she can't find common ground with colleagues, her door has always been open, and for that, I commend her. Thank you.
Thank you, Mr. Kalra. Mr. Mathis, you are recognized in the rear of the chamber.
Thank you, Mr. Speaker. Permission to read.
Mr. Mathis.
Just a headline from...
Please confer with the... Let's stop the clock. Please confer with the Majority Leader. Without objection. Mr. Mathis, you may proceed.
Thank you for permission, Mr. Speaker. So, members, what I want to read here is from the Global News Wire. The headline reads, "The future of work is here. Freelance economy offers unparalleled opportunity for growth, moves to close the gender gap." The first paragraph of this article reads, New York, February 5th, 2020. Pioneered Today issued its freelance economy report based on a survey of over 7,000 freelancers from over 150 countries, providing new insight into the world of freelancers, their motivations, and how their unique workforce empowers global collaboratives by connecting top talent with business anywhere in the world. The report tells the story of an ambitious and courageous workforce that is unwilling to settle for the status quo. Freelancing popularity is attributed to the potential for greater job opportunity, independence, higher incomes, and a promising move in the direction of wage equality. Members, we hear these things of closing the wage gap, wage equality, better opportunity daily. My question to you as we vote on this piece of legislation and anything dealing with the freelancer economy is to really think on what we're moving towards, because the experts in the economy tell us that the freelance economy is closing that gender gap, is providing better opportunity, is providing better economical opportunity for everyone. And to preach equality and equity, we need to really consider these things. Thank you.
Thank you, Mr. Mathis. Seeing no other members seeking recognition, Ms. Gonzalez, you may close.
I want to close by inviting any member of this legislature, if you haven't already, and many of you have, to come talk to me about this issue as it moves forward. Same as last year. We were delivered the Dynamex decision, and a lot of you have honestly come up to me and said, thank you for taking this on, because who wants to be subject to this? I don't mind that, because when that happened, both business and labor came running to us for clarifications. That's what we're working through. It's the biggest labor law changes in decades in California, and I'm going to continue to do that. But a speech for 3 minutes on the assembly floor to get your point across suggests to me, when you've never stepped into my office, that you're not really concerned about fixing whatever issue you have. It suggests to me that you're more concerned with making a political statement. This is not a political statement to me. I know that freelancers, if you will, independent contractors, they have no protections for pay equity. They have no protections for racial discrimination. They have no protections that we have as employees. And so to read from an article and suggest that's an economic expert on the floor when you've never even come talk to me about any issue concerning women in the workplace, again, suggests to me that you're not seeking solutions. I'm seeking solutions. I want to thank the Assembly member from Whittier for helping me get through the toughest piece of this legislation with musicians. I want to thank all the industry folks, workers, individuals who have come to me on all of these issues so we could work through them and get it right. I am committed to getting this right. This is by all means my life's work. But if we're serious about trying to fix as much as we can for as many people as we can and still adhere to a bipartisan, unanimous Supreme Court decision that laid out specifically the problems they saw as these things have been litigated over and over and over again. And it's not for nothing. We have been pulling, before the pandemic, it's a little tough now to ask EDD to do anything, but we were pulling misclassification numbers. And some of you know, you've worked in these fields, and you've seen the misclassification in construction, the misclassification that was happening by the way, in healthcare. The year before Dynamex, 10,000 workers were found misclassified by EDD, not because somebody complained, because just through an audit procedure. 4,000 musicians, 4,000 interpreters. This is a real issue that affects people's lives, and it came to bear when they suddenly lost their job and had no unemployment insurance, and no safety net, and no ability to take care of their family. So I'm going to continue to work on this. I hope you'll vote for this. I hope most of you believe, as my colleague from Big Bear said, it's moving in the right direction. And I, again, invite you to come talk to me about any of these issues. Those who have know we won't always agree 100%, but we'll walk through where we're going and why. It's not random. If you look at our current UI code, it looks a little random, but that came about from 1970 to 2000, all the exemptions there. We're trying to fit 40 years of labor law into 2 years. It's a lot of work. I ask you to join me in this work, and I ask you to vote aye on 1850.
Thank you, Ms. Gonzalez. With that, clerk will open the roll. All members vote. Who desire to vote? All members vote. Who desire to vote? All members vote. Who desire to vote? Clerk will close the roll, tie the vote. Aye 70, no 0. That measure passes.